All right, we have more analysis on this. Let's bring in Rachel Fizet, legal analyst and managing partner at ZFZ Law. Rachel, thank you so much for your time. As Robert Sherbin said, we just heard from Robert Costello within the hour. Let's listen to a bit of that.
And he'd just suddenly stop in the middle of talking about something, point at us, and he'd say, I want you guys to know, I will do whatever the F it takes. I will never spend one day in jail. He must have said that close to 20 times. This was his mantra all day long. You think a guy whose mindset right at that moment is, I'll lie, cheat, steal, shoot somebody, whatever it takes, I'm not going to jail. Well, he went to jail, and now he's on the revenge tour. I understand it, but I don't condone it.
All right, so Robert Costello there referencing, of course, Michael Cohen. Is the main strategy here to focus on Cohen and his credibility, even though it is important to know that Costello was a legal advisor to Cohen?
That's what he's trying to do. So he is trying to undermine what must be the state's very good evidence, if not their best evidence, which would be Michael Cohen's testimony as it relates to those payments made at the behest of Trump for the Stormy Daniels payoff, if you will, for her silence. And so what he's doing there is just simply undercutting or trying to undercut what was said to the grand jury today.
You know, so Rachel, Republican House chairmen are now demanding testimony from DA Bragg. Is this a legitimate request? Can members of Congress interfere?
I think they cannot interfere if the charges are made and they want to know what that evidence is. They have the same right to know, in the same way that Trump has the right to know what the charges are made against him and what evidence the DA has. And no one can know that information or has the right to know that information until an indictment is handed down and discovery is at issue. So once Trump is charged, I think that the DA will open up about the evidence that those charges are made or brought upon.
I mean, how likely is Bragg to respond to this request from Congress, from House Republicans? Does he have any obligation to, in fact, do so?
He has no obligation to respond. If he is subpoenaed in front of Congress, that's a different situation. But just a call for him to come in front of Congress is certainly not something that he's going to listen to. That's a clear political move. All
right, so Rachel, let's talk about this potential indictment. And again, I want to emphasize potential. The former president publicly says it will happen and it will happen tomorrow. How likely is he to know when this indictment would be handed down?
He is likely to know. So the truth is that they are not going to go out onto the street and arrest him in his home or stake him out in some place that he doesn't know they're lurking. What this would be is a very planned surrender. He would go to the DA's office at a planned and certain time. The amount of security would be known. All security measures would be in place, and he would walk in just as he would knowingly walk into the DA's office to surrender himself for his arrest. So he is likely to know. So if he's broadcasting what he knows, that could be happening tomorrow.
You know, so Rachel, it's important to note, as we keep hearing, an indictment is not a conviction. The New York Times says even if Trump is, in fact, indicted, convicting him will be challenging, saying, quote, the case against the former president hinges on an untested and therefore risky legal theory involving a complex interplay of laws, all amounting to a low-level felony. So what does that mean, particularly if we're still talking about a potential felony conviction of a former president?
It's not a slam dunk from the way that I see it. It would be a bookkeeping fraud charge that can be a misdemeanor or a felony. I don't think they're going to do this based on a misdemeanor, but in order for that charge to be a felony, they have to show that the bookkeeping fraud, which means a knowing fraud on the books, took place, which would be the $130,000 that Cohen gave to Stormy Daniels, that they logged as a legal retainer and a potentially legal expense, which it wasn't, it was a payoff, that happened in order to cover up a different crime. And where you get into the different crime is where this can get complicated. What was that second crime that they were covering up? And does the state have jurisdiction over the second crime? And do they need jurisdiction over the second crime? Was it simple tax evasion that was done for, or was it a federal election campaign violation? So it gets a little murkier in proving that second crime. And I think that's where the DA could have an uphill battle.
And hence why we keep hearing an indictment is not a conviction. All right, Rachel Fizet, as always, thank you. Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.